Islam, Shalom, Hotep, Osio, Assalamu alaikum, Hola. How's everybody doing? This is your brother Zach Bay, Indigenous American Moor, coming to you live and in full effect. Please like, share, subscribe to my channel, leave a comment, interact with the content, or dislike. Just, interact with the content, maybe leave a message or something. I appreciate it, family. Okay, I just wanted to go over a quick read really fast. Today we want to check out Commercial Law Applied, Learn to Play the Game by David Robinson. It's a great read. All right, let's just jump right in. I wanted to start here on affidavits. All right, let's see. The affidavit. Commerce consists of a mode of interactions and resolving disputes whereby all matters are executed under oath by sworn affidavit, executed under the penalty of perjury as true, correct, and complete on the basis of each party's commercial liability. Such affidavit is required for an application for a driver's license, etc., or for certifying a document that the system desires a person to be obligated for. Person, remember that word, person, doesn't necessarily mean a natural living flesh and blood person. Such means of signing is an oath or commercial affidavit executed under the penalty of perjury as true, correct, and complete. In court settings, oral testimony is stated in judicial terms, sworn to be the truth, the whole truth, and nothing but the truth. So help me God. I'm sure we've all heard that before, even in like movies on television and different places like that. In addition, the participant must verify and show the relevance of each assertion made to sustain credibility. Commerce exists and functions without respect to courts or legal systems. All right, that's commerce. Commerce is both prejudicial and non-judicial. Commerce is the economic extension of natural law into man's social world. Maxim. Truth is expressed in the form of an affidavit. Never forget that. If you want to submit something to a court or just have something in writing, an affidavit. It's always an affidavit. An affidavit is one solemn expression of his truth. When you issue an affidavit, you get the power of an affidavit. You also accrue the liabilities involved. It's very important. Expression. Solemn expression. Let's keep going. An unrebuttal affidavit becomes judgment in commerce. Proceedings consist of contest or a duel of commercial affidavits wherein the unrebutted points remaining in the end stand as truth, to which judgment of law applies. A claim can be satisfied only through one, rebuttal by affidavit, point by point, resolution by jury, or payment or performance of the claim. So, you can put all this stuff in there. It's usually like involving a contract or something. It'll say you have to pay if you default in some way, shape, or form, or you go through a jury so they can decide, or you just write your own affidavit and say that the contract is incorrect or the person is wrong, point by point. Resolving the conflict or duel between commercial affidavits provides a clean basis for resolving disputes. For in commerce, truth is sovereign. Truth is sovereign in commerce. Maxim of law, number 3 of 10. If truth were not sovereign in commerce, in all human interaction and relations, there would be no basis for anything. No basis for law and order, no basis, no accountability. There would be no standards, no capacity to resolve anything. It would mean that anything goes, each man for himself, and nothing matters. This would be worse than the law of the jungle. In commerce, to lie is to go against the mind. It's an Oriental proverb. I hope everybody can see. Of all that is good, sublimity is supreme. Maxim: if the plaintiff does not prove his case, the defendant, the accused, is absolved. All right, that's the thing about the plaintiff. Is like the plaintiff has the burden of proof when it comes to court and law. Somebody who brings up a claim, that's like a plaintiff or a claimant. A claimant. Somebody who brings up a claim against you, the burden of proof is on them. So like if the courts has a case against you or somebody accuses you of something, the burden of proof is on them to prove that you did whatever they say that you did. All right, that's pretty much what that's saying. And then if they can't prove that, you're absolved. You're absolved of whatever they're saying, whatever claim, whatever crime, allegedly, you're absolved. What the courts are adjudicating and what the government are ultimately making rules about are these basic rules of commercial law. So most of the time when you go to court, almost all of the time, in these de facto courts, it's not even courts, or not even Article 3 courts, but in these de facto courts, which are just operating in commerce, this is what they're doing. They're working in commercial law. So no court, no judge can overturn or disregard or abrogate anybody's affidavit of truth. The only one who can rebut your affidavit of truth is the one who is adversely affected, not affected, adversely affected by it. It is his job, his right, his responsibility to speak for himself, to issue his own affidavit. No one can speak it or write it out for him. So it's always important that you submit your own affidavit if you ever go into one of these de facto court systems. Always, that's what they say, let your paperwork precede you. Affidavits are heavy in that. They always precede you. They always, it's like actions speak louder than words. These pretty much your words. These words are becoming your actions as soon as you submit an affidavit into these de facto courts. All right, let's continue. Commercial law. Wait, let's back up. It also says, here it says, it was saying no court or judge can overturn or disregard or abrogate anybody's affidavit of truth. See, the affidavit of truth is very powerful. So don't forget that. The courts can't just disregard it. If you submit that yourself, not your attorney, or if you get an attorney, not anybody else speaking for you, if you submit an affidavit of truth yourself, they have to pay attention. They have to. They can't just be like, oh, this doesn't make sense. This is nothing. They might try to just mull over, but nah, you make sure that stands true. Copies, triple copies. Copy for them, copy for you, and backup copy for the record. All right. Commercial law maintains the commercial harmony, integrity, and continuity of society to maintain the peace and dignity of the state. Overall, over the millennia, these principles have been discovered through experience and distilled and codified into these 10 fundamental maxims of commercial law. There is no legal issue or dispute possible which is not a function of one or more of these principles. The principles are very important. Once you understand the principles of something, it's very hard to be thrown off by a whole bunch of extra elaborate or just the extra stuff that goes along with it. The principles are very important, are like the fundamental basis. So once you get the principles, it's very, very hard to be thrown off task or to be thrown off point or to be moved off your square because you have the principles down. The entirety of the world's commerce now function in accordance with the Uniform Commercial Code, the UCC, that's always being used whenever you go up inside these de facto courts. That's what they're operating. That's what they're using. Uniform Commercial Codes. The corporate United States version of commercial law. That's what it is. These are the maxims. Just going to go through the maxims and then I'm going to go ahead and end this for now. But this is just one of the reads I'm going over. The 10 maxims of law. Number 1, a workman is worthy of his hire. I'm sure we've heard that before. Most Moors have heard this before. A workman is worthy of his hire. All men are equal under the law. In commerce, truth is sovereign. Number 4, truth is expressed in the form of an affidavit. Not just orally, not just, talking and saying, not just speaking and saying anything when you in there allegedly under oath or under affirmation. Have a affidavit. Truth is expressed in affidavits because they're going to have to go through that point by point and prove that what you're saying is incorrect or wrong or a lie or false. Point by point. An unrebutted affidavit stands as truth in commerce. See, unrebutted. That means unanswered. Unrebutted means unanswered affidavit stands as truth. If they can't disprove what you're saying in your affidavit, it's true. There's nothing they can do about it. That's pretty much a default judgment. And you can add all that in there if you want to, a default judgment. Meaning, if you do not prove me wrong, then XYZ has to be done. A remedy. And unrebutted affidavit becomes judgment in commerce. See, that's what I was just saying. Number 6, it becomes judgment, the unrebutted. You can add that in there. The unrebutted affidavit becomes judgment in commerce. A matter must be expressed to be resolved. See, it must be expressed. That means you can add your remedies in there. You got to say what you want done. He who leaves the field of battle first loses by default. See, he who leaves the field of battle first loses by default. The first one to retreat, the first one to move, the first one to lose ground, to back up, to be moved off your square, the first one to leave the field of battle, you automatically lose by default. Sacrifice is the measure of credibility. What are you willing to sacrifice? What are you willing to put on the line to prove how credible you are? Are you willing to put your life on the line? Are you willing to put your livelihood on the line? What are you willing to sacrifice to prove that you are credible? That that you are truth, that you are sovereign. Gotta be willing to risk it all. Because if you're not sovereign, you're just a subject. And subjects don't have the rights to anything. They only have what the master allows them to have. And number 10, a lien or claim can be satisfied only through rebuttal by affidavit, point by point, by jury, or by judgment or performance of the claim. Now, when you say when it says jury, don't forget it has to be a jury of your peers. It can't just be any kind of old jury. A jury of your peers, or even a jury of uninterested parties. Somebody who doesn't have any stake in the game, somebody who isn't attached, isn't hurt either way, and or by payment or performance of the claim. See, that could be in there. It's like, okay, well, since you defaulted on this contract, or since you did not prove me wrong, you automatically have to do XYZ. Performance of the claim. Get lien. A lot of us Moors know about this word lien here. A lien or a claim can be satisfied only through rebuttal by affidavit, point by point. It has to be point by point. So every issue you bring up in your affidavit, every single point that you bring up has to be answered to point by point. And if they don't, what you say stands as sovereign, stands as truth. All right. Those are the 10 maxims of law. These are the principles I'm telling you about here. When I say the 10 maxims, the principles. So once you get the principles down, it's very, very hard to be moved off your square, from your square. This is just one of the reads I'm still going through here. Still plenty to go through. I've been making notes all through here. Oh, this will be the next page. The maxims, going in a little bit deeper with the maxims here. But that's going to be a video for another time, Moors. Family. I wanted to thank you again. Please like, share, subscribe to the video. And the title of this book again to read is Commercial Law Applied. Learn the game. Learn to play the game. Islam. Shalom. Peace.